Hey everybody, I'm your instructor for business law, and just wanted to take a moment to go into a few things about Chapter 2 to kind of help you get acclimated to the chapter and talk about some of the main content. The recording software I'm using on the computer is only allows for 15 minutes of record time. So if you're listening to this on the podcast or the computer, I may have to take a brief pause and start again, but just let you know that in advance. Okay, so jumping right into it, Chapter 2 is about disputes and dispute settlements. And the main things we're going to talk about are negotiations, mediation, and arbitration. And you've probably heard these terms before. They're pretty common in kind of the lingo. I'm almost certain you've heard of negotiation. You may have heard of mediation, kind of have an idea what that's about. You may or may not have heard of arbitration, but that's an interesting one, and we'll talk about that. It's a really hot button issue in today's environment we find ourselves in. So negotiations in general are basically this exchange between two or more parties, trying to find a middle ground, or you're trying to reach a consensus. That's the word we want to look for, consensus. And so they can be simple or they can be quite complicated depending on what's at stake. And so when a formal proceeding is started in the court system, an ADR, alternative dispute resolution, or way of solving an issue with intent to avoid litigation may be employed. Litigation is involving the courts. And I'm sure you know that anytime you go to court, you've got additional costs associated with that. You've got the legal fees associated with a lawyer or representation. You've got court costs. So that is a expensive endeavor. And so anytime you have a dispute, you want to try to work it out without having to go to court. And believe it or not, that is everybody's preference. Nobody really wants to go to court because of the time, the effort, the money involved. And so you think about it, you want to go to court and sit in there and either hear other cases or have to go through the process of disrupting your life to go deal with a case. So it's just, if you can work it out any other way, that's the best way to do it. So is figure out some middle ground, some type of way to negotiate. So an article in the Organizational Behavior and Human Decision Processes defines negotiation as the process by which parties with non-identical preferences allocate resources through interpersonal activity and joint decision making. So we have different outcomes we want to see, but we negotiate together to try to find some type of common ground. There's a couple different types of negotiation. If two small business owners find themselves in a disagreement over property lines, they will frequently engage in dyadic negotiation. Put simply, dyadic negotiation involves two individuals interacting with one another in an attempt to resolve a dispute. So if a third person comes to play, then you have a group negotiation. So you're trying to work together to find an outcome that is acceptable for everybody. And so rational goals are focused on building, maintaining, or repairing a partnership, connection, or rapport with another party. Outcome goals, on the other hand, concentrate on achieving certain end results. What are we trying to accomplish? And it's good to define those early. Why are we here? What's the goal? That needs to be understood by all parties involved. And so you've probably heard of this idea of win-win, that you want to try to, a good negotiation is where everybody gives up a little bit of something, and everybody, sacrifice a little bit in order to gain. It's, some people don't agree. Some people think it's either all or nothing. That's a zero-sum negotiation, and it's considered to be a hard negotiating style, meaning that either you're going to do this or nothing's going to happen. And it really depends on what's at stake and who's got the power in that situation. As an example, there's a good one going on right now with Epic Games and Apple. You might have heard about this. Fortnite was removed from the App Store. I'm not a Fortnite player myself, but I know that millions of people do play Fortnite, and the dispute is over the fees that Apple is charging Epic to hold that app on their platform. Epic thinks the fees are too much, 30%. Apple thinks that is fair because they do all the infrastructure and they're able to present their product to the entire world. So they have had a disagreement. They've not been able to come to a consensus yet. And at the moment, Apple has basically banned or removed Epic from the App Store, got away with their developer accounts. So this is a zero-sum negotiation. And from Apple's perspective, they've done everything they said they would do in the original contract, and Epic has violated that contract. They said, well, we wanted to try to offer in-app purchases that Apple would not get a piece of that. And whether or not you agree or disagree with the 30% being excessive, the fact of the matter is that Apple had an agreement with Epic. Epic violated that agreement, and so now we're in this kind of zero-sum negotiation. It's all or nothing. So we'll see how that plays out. So win-win approaches to negotiations are sometimes referred to interrogative, while win-lose approaches are called distributive. So you want to try to find that win-win within negotiations. So negotiating style, everybody has different approaches. I myself, I like to try to find the win-win. I like to try to make everybody feel at ease with what's happening and everybody walk away with a sense of fairness of what transpires. Everyone has a different way of approaching negotiation, depending on the circumstances and the person's personality. However, the Thomas Kilmann Conflict Model Instrument, or the TKI, is a questionnaire that provides a systematic framework for categorizing 5 broad negotiation styles. And so these are the 5 styles: forcing, collaborating, compromising, avoiding, and yielding. Forcing: if a party has high concern for itself and low concern for the other party, it may adopt a competitive approach that only takes into account the outcome it desires. We don't care what happens to our competitors or our stakeholders as long as we get what we want. Then we don't care about other outcomes, and that's kind of a egocentric thing to do from a company perspective. But keep in mind, I was talking about this in class earlier today. Companies are a lot like there's a reason why Art of War is part of a business reading list, because it is a very competitive landscape businesses find themselves in. And so having this egocentric model, there is something to that, not my preference. If you could find a way to do it that serves both parties, I think that's a real good win, because you have to keep in mind, your suppliers are also your customers. Your competitors are sometimes also your customers. And so you want to be able to do things in a way that still leaves your reputation intact. You don't want to be known as the bully or somebody that's not willing to work with people. Collaborating, working together to find outcomes. Compromising, trying to give up a little bit to find that middle ground. Avoiding, when a party has low concern for itself and the other party, it will often try to avoid negotiation completely. This is kind of an apathetic approach. And then yielding, finally, when a party has low self-concern for itself and high for the other party, it will yield to the demands that may not be in its own best interest. So I think when a company has been kind of paying its employees under what maybe market demand is, and employees are complaining, they may even unionize, you may yield and pay the employees more, even though it's against your own economic interest. But you realize that paying employees more leads to better retention. It leads to better performance because you've got happier employees, hopefully. And so yielding does have some positive outcomes for yourself. And the graphic that's located on page 18 in chapter 2 talks about these different elements, the concern for self versus the concern for others. And so if you have a low concern for self and a high concern for others, then you're falling to that yielding category. But if you're the opposite, then you're in the feeling category. So I'm going to go ahead and start talking about arbitration a little bit. So negotiations are covered by a medley of federal and state laws, such as the Federal Arbitration Act and the Uniform Arbitration Act. Let me get down into talking about that. Well, before I get into arbitration, the next logical step is mediation. So we mentioned this a little bit in the beginning, mediation, this idea of negotiating, but you involve a third party or a mediator. A mediation is a method of dispute resolution that relies on impartial third-party decision makers, known as mediators, to settle a dispute. And so the real big difference here between mediators and arbitrators are mediators are there just to help bring people together, whereas arbitrators are individuals that make binding decisions. And so the benefits of mediation, it's confidential. It's a creative a way to solve your issues. It does give you control when a case goes to trial. Both parties give up certain degrees of control. So if you go to the court, you're reliant on a bunch of other variables that are outside of your scope of influence and control, whereas within a mediation, you still are in the driver's seat at that point. And so the role of a mediator, just trying to bring people together. These are kind of the steps we go through in mediation. Opening statements of the plaintiff and the defendant, a joint discussion, a private caucus to try to talk about things that have been said, a joint negotiation, and then closure. You're trying to reach a consensus, like I mentioned before. So there is some ethical considerations. Both disputes themselves and those who attempt to facilitate dispute resolutions, i.e. mediators and attorneys, must navigate a myriad of ethical issues, such as deciding whether they should tell the entire truth or only offer a partial disclosure. Yeah, in a mediation, you're not sworn in, as for example, so you have some ethical considerations there. This conflict has long rooted in history, has often been considered in terms of consequentialist and deontological ethical theories. Consequentialist, that's a tongue twister, ethics, sometimes known as situational ethics, is a way of looking at different situations by considering their implications. Someone who follows a consequentialist ethics in mediation or arbitration would consider the impact of his or her decision on the parties in light of their unique circumstances. In contrast, deontological ethics bases its decision on whether the action itself is right or wrong, regardless of the consequences. So, situational, or backing up, consequential ethics or consequentialist ethics look at things, base it on the situation, whereas deontological are put forth the ethical considerations first, regardless of its impact in the current setting. So what I'm going to do is I'm going to take a quick break. For those watching the video, I'm going to make a second video. For those on the podcast, just hang on, I'll be right back. So one moment.